Okay, we're live and entering the stop and frisk. Florida versus JL comes after Terry versus Ohio in this series of cases. This is a 2000 case, and Ginsburg delivered the opinion of the court. The question presented in this case is whether an anonymous tip that a person is carrying a gun is without more sufficient to justify a police officer's stop and frisk of that person. We hold that it is not. On October 13, 1995, an anonymous caller reported to the Miami-Dade police that a young black male standing at a particular bus stop and wearing a plaid shirt was carrying a gun. So far as the record reveals, there is no audio recording of the tip and nothing is known about the informant. Sometime after the police received the tip, the record does not say how long, 2 officers were instructed to respond. They arrived at the bus stop about 6 minutes later and saw 3 black males just hanging out there. One of the 3 respondent, JL, was wearing a plaid shirt. Apart from the tip, the officers had no reason to expect any of the 3 of illegal conduct. The officers did not see a firearm, and JL made no threatening or otherwise unusual movements. One of the officers approached JL, told him to put his hands up on the bus stop, frisked him, and seized a gun from JL's pocket. The second officer frisked the other 2 individuals against whom no allegations had been made and found nothing. JL, who was at the time of the frisk 10 days shy of his 16th birthday, was charged under state law with carrying a concealed firearm without a license and possessing a firearm while under the age of 18. He moved to suppress the gun as a fruit of an unlawful search, and the trial court granted his motion. The Intermediate Appellate Court reversed, but the Supreme Court of Florida quashed that decision and held the search invalid under the 4th Amendment. In the instant case, the officer's suspicion that JL was carrying a weapon arose not from any observation of their own, but solely from a call made from an unknown location by an unknown caller. Unlike a tip from a known informant whose reputation can be assessed and who can be held responsible if her allegations turn out to be fabricated. An anonymous tip alone seldom demonstrates the informant's basis of knowledge or veracity, according to Alabama v. White of 1990. As we have recognized, however, there are situations in which an anonymous tip, suitably corroborated, exhibits sufficient indicia of reliability to provide reasonable suspicion to make an investigatory stop. The question we confront here is whether the tip pointing to JL had those indicia of reliability. While in White, the police received an anonymous tip, and so it's Alabama versus White. In White, the police received an anonymous tip asserting that a woman was carrying cocaine and predicting that she would leave an apartment building at a specified time, get into a car matching a particular description, and drive to a named motel. Standing alone, the tip would not have justified a Terry stop. Only after police observations showed that the informant had actually predicted the woman's movements, we explained, did it become reasonable to think the tipster had inside knowledge about the suspect and therefore to credit his assertion about the cocaine. Although the court held that the suspicion in White became reasonable after police surveillance, we regarded the case as borderline. Knowledge about the person's future movements indicates some familiarity of a person's affairs, but having such knowledge does not necessarily imply that the informant knows in particular whether that person is carrying hidden contraband. We accordingly classified White as a close case. And the tip in the instant case lacked the moderate indicia of reliability present in White, and essential to the court's decision in that case, the anonymous call concerning JL provided no predictive information and therefore left the police without a means to test the informant's knowledge or credibility. That the allegation about the gun turned out to be correct does not suggest that the officers prior to the frisks had a reasonable basis for suspecting JL of engaging in unlawful conduct. The reasonableness of official suspicion was must be measured by what the officers knew before they conducted the search. All the police had to go on in this case was the bare report of an unknown, unaccountable informant who neither explained how he knew about the gun nor supplied any basis for believing he had inside information about JL. If White was a close case on the reliability of anonymous tips, this one surely falls on the other side of the line. An accurate description of the subject's readily observable location and appearance is, of course, reliable in a limited sense. It will help the police correctly identify the person whom the tipster means to accuse. Such a tip, however, does not show that the tipster has knowledge of concealed criminal activity. The reasonable suspicion here at issue requires the tip be reliable in its assertion of illegality, not just in its tendency to identify a determinate person. Firearms are dangerous and extraordinary dangers. Sometimes justify unusual precautions. Our decisions recognize the serious threat that armed criminals pose to public safety. Terry's rule, which permits protective police searches on the basis of reasonable suspicion rather than demanding that officers meet the higher standard of probable cause, responds to this very concern. But an automatic firearm exception to our established reliability analysis advanced by Florida and the United States as amicus would rove too far. Such an exception would enable any person seeking to harass another to set in motion an intrusive, embarrassing police search of a targeted person simply by placing an anonymous call, falsely reporting the target's unlawful carriage of a gun. Nor could one securely confide such an exception to allegations involving firearms. Several courts of appeal have held in pro se foreseeable for people carrying significant amounts of illegal drugs to be carrying guns as well. If police officers may properly conduct Terry frisks on the basis of bare bones tips about guns, it would be reasonable to maintain under the above cited decisions that the police should similarly have discretion to frisk on bare bones tips about narcotics. The facts of this case do not require us to speculate about the circumstances under which the danger alleged in the anonymous tip might be so great as to justify a search, even without showing of reliability. We do not say, for example, that before turning the page, I see a ridiculous amount of footnotes coming from Navarrete versus California. And the caller recently reported had run her off the road and smelled like marijuana. 30 pounds of it. Lower court ruling upholding the stop was grounded in the proposition that the danger exception postulated in JL applies when an anonymous tipster contemporaneously reports drunken or erratic driving on a public roadway, and officers are able to corroborate significant innocent details of the tip, such as detailed descriptions of the vehicle and its location. And the Supreme Court affirmed 5-4 in its opinion, as the dissent put it, that does not explicitly adopt such a departure from our normal Fourth Amendment requirement that anonymous tips must be corroborated, and purports to adhere to our prior cases. So I'm gonna leave it at that. There's a lot more going on in this footnote, but I can turn to page 278. Almost done. Report of a person carrying a bomb need bear the indicia of reliability. We demand for a report of a person carrying a firearm before the police can constitutionally reasonably expect the Fourth Amendment privacy is diminished, such as airports and schools cannot conduct protective searches on the basis of information sufficient to justify searches elsewhere. Finally, the requirement that an anonymous tip bear standard indicia of reliability in order to justify a stop in no way diminishes a public officer or police officer's prerogative in accord with Terry to conduct a protective search of a person who has already been legitimately stopped. We speak in today's decision only of cases in which the officer's authority to make the initial stop is at issue. In that context, we hold that an anonymous tip lacking indicia of reliability of the kind contemplated in Adams and White does not justify a stop and frisk whenever and however it alleges the illegal possession of a firearm. So Kennedy and the Chief Justice joined concurring. It seems appropriate to observe that a tip might be anonymous in some sense, yet have certain other features, either supporting reliability or narrowing the likely class of informants, so that the tip provide the lawful basis of some police action. On one such feature, as the court recognizes, the tip predicts future conduct of the alleged criminal. There may be others. For example, if an unnamed caller with a voice which sounds the same each time tells police on 2 successive nights about criminal activity, which in fact occurs each night, a similar call on the third night ought not be treated automatically like a tip. In the case now before us, in the instance opposed, there would be a plausible argument that experience cures some of the uncertainty surrounding anonymity, justifying a proportionate police response. In today's case, however, the state provides us with no data about the reliability of anonymous tips, nor do we know whether the dispatcher or arresting officer had any objective reason to believe that this tip had some particular indicia of reliability. If an informant places his anonymity at risk, a court can consider this factor in weighing the reliability of the tip. In an instance where a tip might be considered anonymous, but nevertheless sufficiently reliable to justify a proportionate police response, may be when an unnamed person driving a car, the police officer later describes, stops for a moment and face-to-face informs the police that criminal activity is occurring. This, too, seems to be different from the tip in the present case. Instant caller identification is widely available to police, and if anonymous tips are providing unreliable and distracting to police, squad cars can be sent within seconds to the location of the telephone used by the informant. Voice recording of telephone tips might, in appropriate cases, be used by police to locate the caller. It is unlawful to make false reports to the police, and the ability of the police to trace the identity of anonymous telephone informants may be a factor which lends reliability to what years earlier might have been considered unreliable anonymous tips. These matters, of course, must await discussion in other cases where the issues are presented by the record.